Hello, how are you? Good to see you.
Is everybody here who needs to be here?
Good evening.
Need a couple minutes?
Yeah, would you mind?
Yeah, sure.
Can we use one of your offices back?
Yeah, sure.
Great, thanks. Do you mind brief chat?
Oh, you want to have a chat
Yeah,
with us?
sure, yeah.
Okay.
How are you? Good. Good job.
Yeah, hold up there, huh?
Yeah.
The code of silence is in there.
Oh, is that-
Okay, so.
Live stream there. I think they're.
No, I don't do this. The only thing I do is post Facebook Live.
But nobody would know.
Not sure.
It's not working now.
He's remoting in. Oh, that's so weird.
Yeah.
I guess I was just logging on my. Something that I know.
Oh, yeah.
It's
okay.
Yeah, appreciate it.
Yeah.
Nice ones.
Okay. Okay. All right, so I'll do it. Hi.
Oh, there's another. There's another.
There's another door over there. So. From this way or from that way? Yeah. Or I can stand here and turn the camera like I want to. Like. Yeah, maybe I'll just stand by Haley every time. Good job.
That's what I like. Yeah.
No, I'll stand here. I'm literally gonna lie this way. You can't get it to work out.
So you're going to the next day.
It is. Not that fast. When I first got into the live stream, facing my way up the customs.
Did you see when did you see the one where that, like the battery? The guy was sitting there,
All right, nothing to update, but this was provided, which is an additional legal brief from the applicant. All the other dates today. I got you. You guys want to go back here first?
I would make it.
Oh, yeah.
To let you know, so I don't remember the camera or live stream is not working from that, so I have to do it live.
My goodness.
Wait, you think it was weird, so.
Thank you.
Yeah, no problem.
How are you?
Good, Mr. King, how about you?
Pretty good, thanks.
Except for the cold weather.
Yes, sir.
Yeah.
He doesn't make it.
I don't know what that means.
Yeah.
It's like- Yeah.
All right, this is a continuation of the hearing that I believe we started on February 5th. All the parties are here, as I understand it. I guess the first order of business, the board issued an email on February 18th, which we're going to mark as an exhibit 1, addressing the jurisdictional briefs that we received and asking various questions related to that topic of whether the board has jurisdiction or not. So we're going to mark that as exhibit number 1 for this hearing. Are there any objections by the parties or any issues with that?
Not on our.
No question.
Okay, so with that, that'll be accepted. Basically tonight, what we'd like to do is address the questions in that email related to jurisdiction. I think that's the first order of business. Now, last hearing, we swore witnesses in. Let me ask the parties, do you have witnesses you intend to offer?
No, I think these are legal issues.
Yeah, I don't know if I agree with that, but I'll accept your views of that. I think there's at least one factual issue that we raised in our questions. So,
Well, if you want to get into a factual issue, I'm prepared to call somebody.
okay. I mean, it's up to you how you want to do your case. I just want to make sure that we get whatever we need on the record to answer the questions that we had about jurisdiction. You're the applicant. Do you want to start your presentation?
Well, I think I would suggest that whoever's asserting that you don't have jurisdiction ought to go first. That's not me.
So I guess just before we do move forward, we should swear in anybody else who might be testifying,
It's one.
just in case? Were you sworn in? But if you were sworn in at the last hearing,
If you were sworn in at the last hearing, we don't
Okay.
need to have you re-sworn.
okay, so then it doesn't.
Just need to have you, when you talk, identify that you were sworn and you understand you're under oath.
And just a quick housekeeping matter as well, we need to announce that we had an executive session on Monday, February 17th for quasi judicial deliberations related to the legal briefing in this case.
And that executive session was what led to the questions that we submitted on February 18th in the email.
So if the movement, I guess, would like to go first, in terms of thinking of this as maybe a motion on subject matter or whatever type of procedural jurisdiction we might have. I don't know, the parties can talk amongst themselves, but I don't think it matters to the board too much.
Want to go first or second?
It doesn't matter, you can,
You pick.
all right, we will go first.
All right.
All right. And you represent Local Remedy Brewing. Is that correct?
Pardon?
You represent Local Remedy Brewing.
My name is Dusty Elias Kirk and I represent Local Remedy Brewing. With me is Jess Barnes, also representing Local Remedy. So looking at the jurisdictional questions that were asked.
Just for the clear for the record, you're just offering argument as counsel, not as factual. That's
Correct.
okay.
So there were questions asked that I believe need answered by others. So the first question, what process did the building code official follow to issue the certificate of occupancy? So I think Mr. Leland.
I believe it makes sense if Jacob Leland on behalf of the Borough of Oakmont, at least address the first few. I do not have a witness with me. I just wanted to provide a high level background of this process. The first question that you asked was what process did the building code official follow to issue the certificate of occupancy? So to take a step back from the actual issuance of the certificate of occupancy, once Local Remedy Brewing applied for and obtained conditional use approval from Borough Council, they subsequently applied for a building permit with the building code official.
So just so I understand, under the zoning ordinance, there's 3 types of permits or approvals or certificates that are contemplated. Are you equating the conditional use approval to a zoning permit?
It is actually akin to a zoning permit.
Okay.
So a zoning permit is issued by a zoning officer. The zoning permit is issued when the zoning officer has the authority to do so. With respect to Local Remedy Brewing was required to undergo the conditional use process. The zoning officer does not have the authority to approve a conditional use application. That has to come from Borough Council itself. As such, there's no true zoning permit at issue here. Rather, the approval for Local Remedy Brewing came in the form of a grant of conditional use.
Which was issued on what day?
That was issued in May of 2023, I believe.
And that was issued based upon the Borough Council voting.
That's correct.
Now, what day did you say that was?
Exact date.
I have that December 18th, 2023,
December,
there was a
excuse
public
me.
hearing on the conditional use application.
And when was it granted?
It's granted at that hearing, I believe.
But either way, there's, I mean, another separate appeal on that is kind of where we're, the
Correct.
question that we're trying to get to.
So that was granted, and then there was an appeal filed.
That's correct. And that appeal remains pending before the Commonwealth.
That's the one that's at Commonwealth Court 1214 CD 2024.
Yes,
That's
Okay. All right, that, no conditional use ever came before the zoning hearing board and we had nothing to do with that, correct? That's my recollection.
to my knowledge, that's correct as well. All of the issuance of the conditional use approval and subsequent appeal predates my time in the role of solicitor, but that is my understanding in reviewing the files.
Then applicant, is that, you agree with all that?
I think that's substantially correct. The only time we were in front of the zoning hearing board was on ordinance number 1, which was subsequently invalidated by the Commonwealth.
Correct, I understand.
But that was not in this case.
That's-
That's a different
Correct.
case.
That's an entirely different case.
Yeah, it's a different case, but it's that ordinance that is the key to the case.
But to put it on the record, I guess maybe we should take a step back and go through the first part of this email.
We're getting there.
Okay, do all the parties agree, let's try it this way, that there's a conditional use approval issued by Borough Council? That conditional use approval was appealed by the same applicant of this case, and that decision is pending before the Commonwealth Court. Does everybody agree to that?
Yes.
Yeah.
Okay, so just for the record, that was everybody in agreeing.
That's point one in the background, the section of ours.
Yes.
Okay.
And then do you mind if we just go through this?
Okay, the next one, the zoning officer and the building code official are not the same entity. Everybody agrees with that point, correct?
Yes.
Not necessarily.
Well,
Okay.
I can speak to that. So, previously, the zoning permitting was administered by Scott Fody, Borough Manager. Recently, the transition of zoning related permits have been transitioned to BIU. BIU also serves as the Borough of Oakmont's building code official.
I guess it's two different capacities. is it
Correct,
better?
there are, yes, it's not the same capacity, there are different
Same
capacities.
entity, different
Correct.
capacities. Do you agree to that?
I have no idea. This is the solicitor speaking, so if that's accurate, but fine. I have no reason to doubt him.
When
I didn't, what I didn't hear, excuse me, I'm sorry. What I didn't hear was the timing of the transition.
Now, that's what you must say. It's great minds think alike, and so do ours. But, that was a question I wanted an answer to.
And I don't have an exact date for that. There was not a firm date where the decision was made that it was simply going to be handed off, or to the extent that there was, I'm not aware of it.
Okay. So, you just don't know.
I will tell you, the occupancy permit issued in this case was not issued by Mr. Fody as the borough manager. So the occupancy permit is on the form that the Borough of Oakmont issues. And on that occupancy permit is the notation that the occupant certifies that it is in compliance with all applicable federal, state, and local laws, ordinances, and municipal rules and regulations. So that's we referred to that previously in the last time we were here. So that occupancy permit says that everything is kosher with respect to all the rules, regulations, zoning, et cetera. So it doesn't say zoning specifically, but it says all municipal ordinances, rules, regulations, and laws.
But who issues that?
And that would be BIU in their capacity as building code official.
Okay, that's the question.
Okay.
What
That's what I wanted to
name
know.
of the building code official that signed that document?
Based off the signature, I believe it would be Jason Crane Boucher. That's KRAINBUCHER.
Are you looking at the occupancy permit?
I'm looking at the certificate of occupancy, yes.
The name was awfully difficult to read.
I'm familiar with Jason, so
I couldn't
unless
make
there's
it out.
two Jason K's at BIU, I think we can assume it's the same person.
And he's acting on behalf of the Borough of Oakmont.
And he's acting as the building code official on behalf of the Borough of Oakmont.
So do we have a dispute then that the zoning officer and the building code official are not the same entity?
Or capacity, I guess, is the better word. Is there a dispute?
I accept what the solicitor has advised you. I'm sure he's telling the truth. And, but nonetheless, the occupancy permit is issued under the auspices of the Borough of Oakmont, regardless of who issues it. And that officer of the Borough of Oakmont is certifying that the zoning is correct with respect to this property.
Well, that's, I think, is the dispute.
Well, it says right on the, I mean, we can show it to you, but it says right on the form, this is conditional upon your being in compliance with all rules, regulations, laws. It's really broadly worded. It doesn't say zoning specifically, but it says all rules, regulations, municipal and otherwise.
So I think we're referring to a document that hasn't been entered on the record. Would anybody like to do that?
It was attached to the borough's brief, as I understand it.
It was correct.
Okay.
Yeah, it's in
I'm
the,
gonna say it's in somebody's presentation.
I
Here it
think,
is.
I think I have enough copies.
I do too.
I have copies as well.
Okay.
So everybody has it,
Yes.
but for the sake of the record,
For the sake of our record, should we introduce this?
Yes,
Or-
let's-
yes, let's do
Let's
that.
mark that as an exhibit.
You have the one dated November 13th, 2024.
I
Correct,
mark that as exhibit 2.
perfect.
I'll use my version of it. Exhibit 2 is the certificate of occupancy dated November 13, 2024, that was attached to the borough's brief. All right.
And down there in the bottom left corner, Mr. Chairman, where you see the X down there and the signature below it, who I couldn't make the name of. When you see the X, you see the above listed structure is approved for occupancy, provided that the applicant has complied with all federal laws, state laws, and municipal ordinances and approval.
I see that on the certificate.
Yes, sir.
All right, so the next point on here is that our view of the MPC is that we're vested with jurisdiction to hear appeals from, quote, the determination of the zoning officer, unquote. We don't have a jurisdiction to hear appeals from the determination of the building code official. Does everybody agree with that?
I agree to the extent that that's how, that the statute reads as follows, if you'll indulge me. Appeals from the determination of the zoning officer, including but not limited to the granting or denial of any permit or failure to act on the application, therefore, the issuance of any cease and desist order or the registration or refusal to register any non-conforming use, structure, or lot. Applications for variances, number 5 says applications for variance from the terms of the zoning ordinance. So this, in our opinion, is an appeal from an action by the borough of Oakmont with respect to a decision that this property is being occupied and used in accordance with the zoning laws of this borough.
So, go ahead.
Good.
Maybe we take it kind of piece by piece here, this third bullet. We all agree, I think, is what I'm asking. Do we all agree, all the parties, that the MPC vests this board with jurisdiction to hear appeals, quote, from the determination of the zoning officer, quote, that is section 909.1, subsection 8.3. That's what that section provides, correct?
I agree. I agree that it says what I just read into the record.
You
Which
read
is
the
part of what
entire,
you said.
you just read the entire
I did.
909.1.
Which goes on to say, including but not limited to the granting or denial of any permit.
Correct.
Of the zoning officer.
Right.
Correct.
First,
It specifically refers to the zoning officer in that section, grant of jurisdiction.
I'm not denying that. It does say that, but
That's the point I think we were getting.
But this is the building code official.
Correct.
Correct.
One of the
So we're
issues that we have
apples
to
and
decide
oranges.
is the building code official's action on this certificate of occupancy a quote unquote determination of the zoning officer. That's where we have an issue. And that's where we need guidance from the parties as to how to address that issue. Because the borough's position, as I understand it, is that the building code official is not the zoning officer. And your position, I don't think you would disagree that the building code official is not the zoning officer, correct? You don't disagree.
I understand what the solicitor said, that it used to be one and the same. And that the manager probably at the time that the whole thing started, I don't know the date by which they switched, but they were one and the same. It was the borough manager.
I don't think he said they're one and the same.
They were.
He said Scott was the zoning officer and now he's transitioning that role to BIU.
Correct.
Now.
BIU is
He was
handling,
never the building code official, correct?
correct.
and Scott
This
Floyd's
is-
signature is not on the certificate of occupancy. Do we
That's-
agree with that?
Sorry, just real quick.
I
Do you have this young lady's name with the dark
I
hair?
think I have it, but I'll get her card.
So-
Lawrence is your last name.
Yes.
Okay, sorry.
No, I apologize.
The certificate of occupancy is dated 11/13/24. That's the date on the document that the borough has given us.
Correct.
So it was signed by Jason Crane-Hucher for BIU. So clearly, as of that date, he was signing it as the building code official, not as the zoning officer.
Right.
So I think that we're kind of going in a circle here. And it's it's getting confusing, but this is the operative document.
Yeah, I don't think we're going in a circle. I think we all understand.
It also provides at the top that this is an action of Oakmont Borough. Attention, Scott Fody, Borough Manager.
I don't think there's any dispute that this was an action of the local. There's no dispute.
Okay.
We're the zoning hearing, we're the zoning hearing board. We address zoning issues.
This is what
That's the issue.
this is why I suggested prior to starting to this evening, that we would be willing to defer tonight to wait until the next hearing, which is before the Board of Appeals on the occupancy permit.
When is that hearing scheduled?
Well, we were contacted by someone at my office was contacted to ask if March the 5th was agreeable to us. So I assume when we spoke earlier, I don't think anybody else got a call, but we got called with March. We were the applicant. Was March 5th convenient? And I said it was. So I assume they'll call everybody else.
But the point is that he's going to come back here and make the same argument.
Correct.
So I think we should make the arguments now. And then you will have a record, and then whenever the certificate of occupancy appeal gets heard, we'll have a complete record. And then those can all be decided or appealed or.
Yeah, just make sure we understand the record. You have an appeal of the building occupancy permit before the UCC board of it.
Yes.
And you're raising the same issues there, correct?
Correct. We took a cautionary appeal here as well. So to make sure that,
I remember we had that discussion at the last hearing.
yes, I told you I didn't want to miss you.
Well, and then when I asked you a little bit more about that, then you told me that was tongue in cheek, so.
Only a little bit.
I guess I'll get at is, if you have this appeal with the exact same issues already pending, I agree with you, it might make more sense to have this proceeding postponed until that time, but local remedy brewing would like a ruling on jurisdiction, and we're happy to do that if that's what they want to do.
Well, that's fine. I mean, whatever you decide to do, you decide to do, but I was trying to make everyone's life, in my view, at least in our view, a little easier, but
We're all here tonight, so.
sure, because anyone can
finish
appeal
through.
whatever decision you make.
Do we have the building code official and zoning officer here today?
They are not present.
How are we going to answer one and two, was the determination the zoning officer made to the building code official? How do we know that if they're not here?
Well, I think it's a question of law, and I'm prepared to explain our
That's a
position.
question of fact there.
Not
Yeah,
necessarily,
yeah.
Mr.
Well,
Sincere.
that's the way you have it, the way it's written, the determination of the zoning officer made to the building code official. That is, you're asking specifically if the zoning officer spoke with the building official, the building code official in making its determination.
I can tell you how the
Is
process.
that, let's start there. Is that
Hang
the
on,
question?
hang on a second. Your appeal was filed on the basis that a determination of the zoning officer is before us. I expect the applicant, when they file that, to have some facts or evidence that supports what that determination was.
This is the evidence, the certificate of occupancy, which the applicant says, and the borough says, that you must be in compliance with the zoning ordinance. And so certainly the code officer would not have issued a certificate of occupancy had he or she not determined that this was, that the property was in accordance with the zoning ordinance. There's no way that any person worth their salt in this position would issue a certificate of occupancy without determining that the applicant was in conformance with the zoning ordinance.
And if I may,
Okay, let's hear the borough on this.
Attorney King is essentially arguing that the invalidation of the parking ordinance, that's ordinance number 01-2023, serves as an automatic revocation of the certificate of occupancy and the conditional use approval that was granted to local remedy brewing. That is a question of law that is outside of the purview of the powers that are vested in this board tonight. That's also a question that he is currently raising before the Commonwealth Court, which again is on appeal still, as well as the Court of Common Pleas of Allegheny County. He's recently filed for an injunction where he raises that exact question. But he is operating under the assumption tonight that the building code official and or the zoning officer automatically should make a determination that based off of the invalidation of ordinance number 01-2023, that the property was not in compliance at the time of the issuance of the certificate of occupancy. I can almost guarantee that local remedy brewing would tell you that the revocation of an ordinance does not, or excuse me, the invalidation of an ordinance does not serve as an automatic revocation of anything taken under a validly enacted ordinance. Also, at the time that the certificate of occupancy was issued, we were still within the appeal period of the Commonwealth Court's decision to strike down that parking ordinance, which means that decision was not final at that time. As such, both the zoning officer and the building code official, to the extent a decision was theirs to make, could only confirm that local remedy brewing was granted conditional use approval by Borough Council. That granting was still in effect at the time that the certificate of occupancy was issued.
And the law is abundantly clear in this Commonwealth that one who proceeds while an appeal is pending, as Mr. Keefe clearly told the applicant when they were here, that's on the record, and when he opposed it, clearly told them, listen, I have an appeal pending. What are you going to do if I win that appeal? And the law is quite clear. The case law from the Supreme Court of Pennsylvania is quite clear that in the event that you proceed at your own risk. This is the classic case of proceed at your own risk. And so they proceeded at their own risk. And so the indication of that they were in compliance with the zoning ordinance is wrong. And so that's why we're here, because when we get to the code office appeal, somebody's going to say, well, what, we're not in charge of zoning, right? So it's sort of a conundrum that is created by the fact that we rely on the fact that the zoning, part of what the solicitor said, I agree with, but part of it is that it is, when that ordinance is invalidated, then that invalidates anything that happened under that. And the cases are quite clear about that. The Supreme Court has said, if you proceed to build, if you proceed to go forward, knowing that there's an appeal filed, you do so at your own risk.
And I-
The case clearly says that. I don't think that's really in dispute. Are these the same arguments that you have pending in your conditional use appeal and your UCC?
Anywhere I could find a file, if I could file in federal court, I would have.
It's a conundrum that has a very clear answer, and it's for the Court of Common Pleas of Allegheny County to decide. And there is a decision, there's a hearing scheduled for March 12th on an injunction that Mr. Keefe filed against local remedy brewing. The very narrow question of law raised in that case is, what effect does the invalidation of ordinance number 01-2023 have on local remedy brewing certificate of occupancy and conditional use approval? This is not a conundrum that does not have an appropriate forum to hear it. It's just, this is not the appropriate forum to hear that question.
So-
Before you talk, let me ask a question. Is the building code official, the point Mr. Leland made is that at the time this permit was issued, the appeal period for the Commonwealth Court decision hadn't expired. So it wasn't, you agree it's not a final ruling until the appeal period expires and there's no appeal filed.
Yeah, it's done now. I don't know the exact dates.
Well, I know the dates. So November 6th was the hearing, was the Commonwealth Court decision.
Yes,
And
day after election.
Yeah, and then the 13th, the permit was, the occupancy permit was issued. The appeal period would not have expired till what, December 6th.
Listen.
So do you agree with that
Listen,
proposition generally?
Let me tell you something. I don't know where you're going tonight with this thing, but I want to tell you something. If you, on the day after election day in the morning, I got a text with this order, and the order struck down ordinance number 1. And so if after that point, somebody issued this occupancy permit or confirmed that the zoning was appropriate, somebody was doing so at their own risk. And not only the occupant, but the borough itself. So if you knew that a 3-judge panel of the Commonwealth Court unanimously struck this ordinance down on November 6th, why in the world would you ever issue an occupancy permit a week later? Unless you were
Because-
just out to get John Keefe.
No, because,
appreciate
can I
all
speak, please?
Yeah.
I need to,
Let me-
because.
Okay, go ahead.
Because after that ordinance was struck down, the underlying ordinance that was in effect before was effective. It wasn't like there wasn't any parking ordinance, there wasn't any ordinance in effect regarding, let me speak, I've let you
Yeah,
speak.
Let her finish. and-
Oh, I wouldn't interrupt you. I thought you were done.
So.
When you're done, let us know.
So, there was an ordinance in effect that says what the parking requirements are. And I think that the building code official could go look at the building and see if it was in compliance. The zoning officer, if they did that, could determine whether there was sufficient parking, because there's parking that was in effect prior to this ordinance that was struck down. So I think he is confusing the fact that one ordinance was struck down to say that nobody could get an approval after that? Is that what he's saying? Because that's,
That's not what I'm saying.
Well, I guess
Listen,
it kind of raises the question that I think we've been trying to get at, and that is, what does the building code official rely upon when he issues the occupancy?
And to the extent that,
Does he even take into consideration
I agree with you.
the compliance with the parking? I don't know that there's any testimony or evidence in the record to that effect.
There isn't. And
So
there
then
isn't here.
how can we, as a zoning board, say this determination of this building code official was correct or incorrect?
Well,
That's the jurisdictional conundrum that I think.
well,
we're
that
in
is
right
gonna
here.
be heard, and he has an appeal of that's gonna be heard elsewhere.
this stuff,
He does.
this stuff about
Okay.
we had parking and all that, that's fine, except, we don't agree with it, that it was proper. But secondly, you have to file a new application. You can't rely on the old application that relied on ordinance number one.
Well,
The
that,
old application relied on ordinance number one. Ordinance number one is struck down. You can't say, well, I was relying on ordinance number one is struck down, but you know what? I think I might comply with this. That was never said. There is no evidence. There's nothing that's ever been submitted, to my knowledge, unless the solicitor corrects me. There's nothing that I know of that's ever been submitted to this borough to say that we comply with the old ordinance.
I
There's
think-
no new application before the borough.
I don't think that a new application before the borough is needed, because there was a conditional use hearing. And I think the borough solicitor can determine that. He's trying to supplant his views for the borough solicitor. There's a parking lease in effect right now for this, and there is an opinion that there's sufficient parking by the building
What
code
you're
official.
showing-
I can submit those to
You're
you.
showing a document? What
Yes.
document are you showing?
Well, we can mark it
This will be exhibit 3.
exhibit 3. Yes.
And what-
You have one.
Yeah.
Yeah, here.
Mr. Chairman, I just wanted, I have great respect for Attorney Kirk, but I'm not a supplanter of the borough solicitor.
Well, you were trying, Todd.
Nor do I
don't
want
think
to
she
be
done
the
it
borough,
personally,
nor do I want to be the borough solicitor. We've known each other a long time,
Yes.
so.
So we're gonna mark it as exhibit 3. It's an email from Jason Crane Booker to Scott Fody dated February 2025. You want me to read it into the record? It says, "To who it may concern, this letter serves to confirm the off-street parking configuration plan for the property located at 531 Allegheny Avenue, parentheses, local remedy road, including an additional 18 off-street parking spaces provided to the occupants of 531 Allegheny Avenue through a private lease agreement with an adjacent property owner, complies with Borough Code, Chapter 205, Article 8, Parking and Loading, as was in effect prior to the adoption of Ordinance 01/2020."
This is, I'm going to object to that being in, I understand you read it in the record. I'm going to object to, listen, this is written today. Without, this is ambushed, of course. It's written today and we don't produce.
Let me
Mr.
assure you,
Cranebrook.
we're not trying to ambush you.
Not you, you're not.
Or we're not gonna let her ambush
Well,
you,
now.
okay?
now
This is
we're
the first
accusing
time-
you of an ambush.
It's
So-
not the first time they bring this up.
We're not gonna let anybody ambush you, okay?
They just did.
No, we came
For the
here,
record, you'll have
we-
opportunity to respond.
we
I-
came here
I have no
today.
problem.
Well, I just want to say that I'll be given the weight that is entitled to be given by discretion of the board. If that's no weight, that's no weight. If that's great weight, that's great weight. Is what it is.
The insertion in the email is essentially that it complies with the prior one.
And I
That's
can
right.
tell you right now, we strongly, vigorously disagree with that. And had I even had the courtesy of somebody, whoever got this, I don't know who requested it, I don't know who it's written to, I don't know who orchestrated this, but at 10:31, at 10:13 this morning, I could have come here tonight to argue about whether this was appropriate or not, but instead, the borough comes without this guy, without Mr. Cranebrook, and produces this document at 6:45 at night. I mean, if that's not an ambush, I don't know what is.
No, I'm gonna object to orchestration, and we've been here, you came at 6 o'clock and asked for a continuance, so we.
No, I did not,
No,
I did not ask.
So I
for
could-
All right,
We
let's
could
go.
go,
I did not ask for.
Let's stay calm.
Hold on.
Okay.
So let's just kind of reorient ourselves all together very quickly. We have a court reporter here. I know that we all want to make our points this evening, but we need to speak one at a time. Somebody's phone keeps going off. No, it's all right. I just wanted to kind of hit that on the head because I was finding it a little distracting. And let's kind of reorient ourselves back to the issue at hand, which is jurisdiction. We're starting to get into the merits of something that this board might not be able to even hear. So we left off.
If you're gonna allow them to introduce this letter, okay, we question the validity of the parking spaces and that they comply with
Distance,
with the distance,
size,
size, et cetera. So
handicap.
just so that that's
accessible.
on the record as well.
So I appreciate that, but again, this board might not even get to that issue at this point. We're way far ahead of where we need to be. And I think this board appreciates that a witness was not presented to be cross-examined about this letter, that there's some evidentiary issues that need to be taken into concern, but
The letter was introduced into the record because it was discussed. It's not, I can tell you just by reading it, it's not determinative at all of the jurisdictional issue. All right, this goes to the underlying merits of the dispute. The question that we still are trying to wrestle with is, what does the building code official have to do in issuing the certificate of occupancy with the parking or the zone? And I don't think that question has been answered.
I think it's that's a factual issue.
I believe it.
We don't have these people here tonight.
well, let's be clear, anybody who called them to have them here this evening.
Right.
I think we all knew that this was gonna be a jurisdictional hearing, and any of the parties could have asked for a building inspector. Nobody did. So that's where we're at.
That was kind of our purpose in sending the email out so that everybody could be prepared to bring whatever witness they felt was necessary to answer the jurisdictional question, which is, what did the building code official rely upon with respect to a quote unquote determination of the zoning laws?
And our position is the certificate of occupancy clearly indicates that this person is acting on behalf of the borough of Oakmont. Whether he's got the same title or not, he's acting on behalf of the borough, and he is signifying that he's in compliance with the zoning ordinance. And that is just not true.
I hear what you're saying, but there is no place on this certificate where he says you're in compliance with the zoning ordinance. You're reading this broadly on municipal ordinances. I think Exhibit 3 does go to the issue of whether that, whether local remedy brewing is in compliance with the underlying ordinance that isn't invalid. But we can't make that determination because we don't have any evidence in the record.
You can't accept this as hearsay anyway.
Exactly, we're not gonna accept that as the definitive on the factual issue. So we don't have any. You may be correct that this wasn't in compliance with the municipal ordinances, or you may not be correct on that. We don't have evidence on that, and I don't know how we can make a determination without knowing what it was. Well, I don't know how we can have jurisdiction without knowing what it was that the building code official looked at with respect to zoning and parking in issuing the certificate of occupancy. That was the question that we thought or hoped that the parties would be prepared to address tonight, and rather than just legal argument.
Well,
And I don't think we're there yet. So I'm not even sure that at this point we can say we have jurisdiction or don't have jurisdiction, because we don't have the evidence on that. We have your legal argument on that. But beyond that, I don't know how we make a determination on that at this point.
Well, I think that the solicitor was explaining his
Okay.
viewpoint on that, but we haven't gotten through all of that.
All right.
We got a little off road.
Little side.
Well, I'd suggest we take I'd suggest we adjourn, and then we take the deposition of the zoning officer and the code officer in conjunction with this and submit it to the board.
So what would the deposition be taken pursuant to, like, what case?
Pursuant to this case.
So depositions aren't really a part of a zoning proceeding,
There,
but
there's certainly, you've been around long enough to know, there's plenty of depositions taken in these
If
proceedings.
the
before
parties
zoning.
agree, they can do it. Do the parties agree to have a
Right.
deposition of the building code official?
well, we could also just have him here to be cross-examined and examined, which is what I would suggest would
That'd be fine with me too.
But, maybe, Well,
It might make it a lot easier if he had a deposition rather than having to convene all these people.
I'm sorry, I did not mean to interrupt.
Go ahead.
I would say respectfully, regardless of whether the building code official is deposed or we reconvene to bring him in, I think regardless of the first three questions that you asked, we're still left with question 4, which is this matter ripe for adjudication? The answer is no. Mr. Keefe has currently filed appeals pending in the Commonwealth Court of Pennsylvania, the Court of Common Pleas of Allegheny County, and the UCC Board of Appeals. Let's say hypothetically everything, I'm not saying it is, but hypothetically, let's say everything that Attorney King has said is correct. Is
Thank
that
you.
still a question? Emphasis on hypothetical.
You know,
Is it still a question for this board to answer? And the answer to that is no.
I think I can't agree with you on that, because if this board has jurisdiction over a zoning official determination, we have no choice but to hear the case.
It could be stayed pending the outcome of the Court of Common Pleas.
It could be, but the parties want a ruling on the jurisdiction. And before, we stay. And we're happy to do. But we don't have, at this point, enough information to be able to make that determination.
But there is also an appeal pending at on the certificate of occupancy at the UCC.
Correct.
And that's why I say we're kind of going in a circle here. So.
That's
And
why I started out suggesting that we wouldn't be opposed to, I didn't ask for anything. I just said, if anybody's interested, we're willing to wait until we get to the occupancy permit hearing and see if that doesn't resolve all of these issues.
There's been
That was my
evidence-
suggestion, but if nobody wants to do it.
There's been evidence introduced into the record that there's an injunction hearing pending March 12th.
Sure.
Is the
Right.
building code official going to testify at that hearing?
He is now.
no, he's going to be deposed. His deposition
Okay.
has been scheduled by
So the
by
building,
Mr. King.
okay, so the building code official's deposition has been scheduled.
Scheduled, yes.
When is that scheduled for?
The week of, I don't remember exactly this, there's a lot of people in this thing. The week of March, the 3rd, 4th, 5th. 6th.
Yeah, it's
2 weeks from now,
2
less
weeks
than
from now.
less than 2 weeks from now.
So it would seem that the building code official's deposition would have a lot of bearing on whether we have
I'm
jurisdiction.
gonna be there. I'm gonna ask him the same question you asked me.
That would be great.
If I just could make one point, I've heard Mr. King say that Jason, I'm gonna butcher his last name.
I think we'll have tonight.
Okay, was acting on behalf of the borough, and it says building code official. But just because he was acting on behalf of the borough does not give this board jurisdiction. We talked about how it's a determination of a zoning officer, and we've heard no evidence that he was acting in the capacity as a zoning officer.
Except you've heard no, I'm sorry, I didn't mean to interrupt.
I think you interrupted Alexis, not me, but go ahead.
I was just gonna say, I think that that's the point that we've all landed on.
I agree with you 100%. Just goes to the action of the borough doesn't make any difference for our jurisdiction. Our jurisdiction depends upon an action, a determination of the zoning official.
And as
That
we sit
answers
here
the
tonight,
question.
we don't know what the testimony will bear. We'll find out.
Well,
Did he
There's been no
talk to-
evidence that he's acted in any other capacity but the building code official.
he is a building code official, it
There's
said,
been nothing
that's
wrong.
why I gave you that letter, that's what it
Mr. King's
says.
point is that the certificate of occupancy talks about being in compliance with all municipal ordinances. And if in fact the building code official took into consideration some parking issues or compliance with the zoning ordinance, then there might be jurisdiction for this thing in our view.
I think.
It's possible.
So what I would like to know, I guess, from a legal perspective for this board's consideration is we heard this evening that there was a conditional use approval that was provided, which is akin to a zoning permit per the borough solicitor. You know, when a conditional use is granted, it's supposed to comply with this section 205-405A4 of the ordinance that says the proposed use is in conformance with all applicable requirements of this chapter, including but not limited to Articles 3 and 10 of the Oakmont ordinances. So this chapter, generally speaking, is the zoning ordinance. So they have to find as a conditional use that it's in compliance with the zoning ordinance. There's a factual question still. Did the borough's building official rely on the conditional use approval, or did he rely on something else, right?
But Ms. Wheeler, if I may, all of this challenge stems to the time of the issuance of the certificate of occupancy. At that time, the determination of the Commonwealth Court was not yet final, which means even if they went and looked through every single thing, and by they I mean the zoning officer, they would find the property to be in compliance at the time of the issuance of the certificate of occupancy. The decision of the Commonwealth Court was not yet final.
There's no, I disagree with that completely. There was no appeal taken. There's no automatic stay. The three-judge panel of the Pennsylvania Commonwealth Court unanimously struck down the ordinance on November the 6th. And on November the 12th, I guarantee you that the borough knew that the ordinance had been stricken. And so how in the world could anybody operating on behalf of the borough of Oakmont, would any of you three gentlemen on this board, or would the solicitor, or would any of these ladies, these are good lawyers here, that would any of them issue this? Would you sign this occupancy certificate knowing that three judges unanimously struck down the ordinance that they relied upon? There's no way in the world. I disagree with counsel significantly.
I don't think we can look back on December 6th, once the decision became final, and then backdate it and say, well, at the time of the certificate of occupancy, the property was not in compliance with.
You don't
all
have
the
to do that.
ordinances.
You don't have to do that.
That's what you're asking.
Listen, you could have.
One at a time, folks.
Then you could.
That is what Attorney King is asking this board to do. Again, at the time of the issuance of occupancy, that decision, contrary to Attorney King's assertions, was not a final determination, which means everything was still good law. It wasn't.
That's just not the law. That is, with all due respect to Mr. Lehman, that is not the law. Listen, if you know that an ordinance has been stricken and you're the borough and you want to check and you don't like what's happened, you can file an appeal. The borough didn't file an appeal. There was no appeal taken.
But it wasn't a final determination at the time of the certificate.
It was a determination.
It was a determination,
of the
but the
Commonwealth
appeal
Court.
hearing was still.
Gentlemen,
One at a time.
I can't,
Hold on,
I'm
guys.
not
One at a
gonna
time.
record here.
If I may just kind of, again, redirect us, because we're getting more into the merits of things, and I think we're at an ability to address at this moment. I see what the borough is saying of the building inspector could have relied on this, or, and it would have been proper, but I think that the board's concern is we still don't know if the building inspector relied on. So saying hypothetically, he would be correct if he relied on something, they just want to know what the process was. and what was relied on. So that's kind of where we are. It seems to be maybe more to adjourn in an executive session, and we can have some discussions on how to proceed, given the fact that the building inspector isn't here this evening. Does that seem like something you'd be, or do you want to keep proceeding?
Well, Alexis is exactly correct. What we are trying to get at is what is the specific determination of the zoning officer that the building code official will want. We do not have an answer to that in this record tonight, in our view. And we can't rule on jurisdiction without knowing that issue. And so, as I understand it, you're gonna be taking the building code official's deposition in 2 weeks.
Right.
And you're also having an argument on an injunction and possibly a UCC appeal on March 5th.
Yes.
So, seeing that, as a result of that, those proceedings, you will have an answer on that question to see if we even have jurisdiction. Does everybody agree with that?
I think we can agree with that, but I think what is still lost is there still was an underlying ordinance here.
I understand, but that goes to the merits. That goes to the merits of it. So let's say hypothetically that the building code official says, I relied upon the zoning officer. This is purely hypothetical. I relied upon the zoning officer telling me that this thing was in compliance with an ordinance that wasn't invalid. They can contest that and say that's an incorrect determination. That's what we have jurisdiction. But that just goes to the underlying merits. To know whether there is that issue, we don't know that right now.
Well, I just think that Mr. Keefe is having this business fight on multiple fronts, and I think that's what Jacob was getting at. That there is an appeal at the Commonwealth Court on the conditional use. So that hasn't been decided yet, but if that were decided, that would probably decide all of these matters. So for us to have to go to the, we're still going to the UCC on the building code. We have that appeal. We have an appeal on an injunction. This is a huge burden on a small business. And so now you want us to come back on the zoning board. I think the issue is that there are cases that are above the zoning board right now that may decide this.
Well, I think that's pretty much what your summary was. I mean, it's true.
I think that's kind of.
That's why I suggested perhaps an adjournment of this until we have the opportunity to take, and I'll listen, I'll make it easy.
But my
I'll
point
make
is
a-
we
I will-
shouldn't be back.
I'll make it
That's
easy.
why
I'll make a
we
motion.
wanted to do this now. We shouldn't have to keep coming back and going in this circle. That's my point.
I'll make it easy. I'll make a motion to that effect for your consideration. If you want to do it, fine. If you don't want to do it, to postpone this matter until we are able to depose the building permit off the code officer, and to reach the conclusion of the very statement that you made, which I think is accurate. What did he take into account? What did he do? What did he rely on?
So are you proposing that would be indefinitely postponed and?
The board cannot indefinitely postpone.
Well, you can set it for another date past the.
We have 45 days to reconvene for the MPC.
So we can, if we reconvene in 30 days with the idea that that should get you all the information that you need, and maybe we don't need the follow-up here.
That may be, and we're going to be in front of a judge in Allegheny County on an injunction on the 12th, I think it is.
Yes.
And so there's that will happen, the depositions in conjunction with that will happen, and perhaps the code hearing will happen as well. So it may move all of this at some point.
Well, it seems to me though that Alexis isn't going to be in these depositions, and she is your legal counsel. So what we are really being asked to do is bring Mr. Fody and Mr. Jason Cranberger back here And that's why I'm saying, we are just going in a complete circle here.
Well,
This-
sorry.
Go ahead. Go
I
ahead.
mean, theoretically, if this board's desire is to, continue the hearing to have some sort of factual resolution, one way that could be done potentially is by just introducing the deposition transcript because it's a sworn statement that both parties were able to present cross-examination for. But that's again up to however the parties want to, litigate.
I don't need to bring them back. We're gonna depose them. If we can't ask them the questions, well enough, then shame on us. We'll be able to ask them whatever we want.
I'm presuming that the deposition will answer whatever questions need to be addressed, and you won't need to call a witness at the next hearing.
Pretty sure that I'll be able to accomplish that.
I have no doubt.
Thank you.
Yes, but you won't have heard him. And you won't be able to judge whether you agree with him or not. And your counsel will not have heard him. And, I just think, again, we're being asked to come back here when there's all these other pending cases. And so I think the issue that Alexis asked at the outset is, why are we here in the first place?
Well, she didn't
What is
ask it in a
what
negative
is
way.
the-
She just asked.
I know how she asked it, Tom. She's asking us, is there jurisdiction here where there's all these other pending cases?
It's probably hard for you to believe that we went to the same law school.
Which one was that?
No, Dickinson.
Yes.
I should have gone to Duke King.
She went to Duke.
Well,
Okay,
Looked at her, yeah.
So would the board like to adjourn into executive session to deliberate as to next steps or? That's up to the board.
Why don't we take 5 minutes? Maybe 10.
This is the hero of Dickinson. She is.
I don't know about that.
Oh, she's done it. Miraculous.
It's up pretty well yourself.
These things get big after.
My
All right, we've met in executive session. I think the board's determination is that we do not have enough evidence in the record to make a decision on jurisdiction at this point. As a result, we are going to continue the hearing for 30 days till March 26th, Wednesday at 6 p.m.
Or not this council available.
According to the council's schedule that we looked at, that date should be available, but I don't know.
March 26th.
Wednesday?
6 o'clock.
Well, my client will not be here.
Could we possibly push it back to the following Wednesday, April 2nd?
April 2nd is okay. with us.
Is that past 45 days or?
No, it's still-
It shouldn't be.
Yes, yeah, that should be fine, because we would have 2 weeks from. I think the 45th day is gonna be,
Which say April 2nd.
April 2nd, 6 p.m. Does that work for everybody?
Checking right now. My client will still not be here, but we will make other arrangements if that needs to be.
so April 2nd at 6 p.m.
April 2nd, 6 p.m.
Does that work for the borough calendar?
Yes.
Somebody's, thank you.
Thank you very much.
Now, I presume, let me say this, presume you'll be able to figure out from the testimony of the building code official or the depositions that you take, whether this board will have jurisdiction. So on April 2nd, if you think there's gonna be enough evidence to show we have jurisdiction, then we ought to be prepared to go through the whole hearing on merits and everything. So if you want to prepare something that's in opposition to this exhibit 3, if it looks like there's gonna be jurisdiction for the board, and I think we've laid out pretty clearly what we view as necessary for jurisdiction, then I think everybody needs to be prepared to come with whatever witnesses they have for that night, so that we can get this done finally, once and for all.
Thank you very much.
Okay? Thank you. You have a motion to adjourn.
Okay, big chair.
Nobody opposed.
Nice meeting you.
Yeah, you too.
Okay.